there's been a lot in the media about the ICJ supposedly declaring that Israel is plausibly committing genocide, but that's categorically not what the ICJ actually said. And if one looks at paragraphs 30, 62, and 84 of the court's decision, it's clear that the court says it's not making any finding about Israeli violations at all, and it's not even determining that it has jurisdiction. It simply hasn't got to that phase of the proceedings. So it's strange for these legal experts, these leading legal names, not to recognize that there was no finding on the merits. The word plausible is actually a little tricky in the court's jurisprudence. The question of plausibility is over whether South Africa is plausibly making a case that falls within the terms of the Genocide Convention, if it's proven true at a later stage, and that's it. So the idea that they put forward in this letter that there is a plausible genocide going on is actually false in terms of the ICJ hearing.
You know, I'm glad I have a chance to address that, because the court's test for deciding whether to impose measures uses the idea of plausibility, but the test is the plausibility of the rights that are asserted by the applicant, in this case, South Africa. So the court decided that the Palestinians had a plausible right to be protected from genocide, and that South Africa had the right to present that claim in the court. It then looked at the facts as well, but it did not decide, and this is something where I'm correcting what's often said in the media, it didn't decide that the claim of genocide was plausible. It did emphasize in the order that there was a risk of irreparable harm to the Palestinian right to be protected from genocide. But the shorthand that often appears, which is that there's a plausible case of genocide, isn't what the court decided.